while we're waiting for everyone to get in. I think just welcome everyone to the session on CC and privacy. And so Sarah is going to intro, and then we're going to have a couple expert panelists speak. And then we'd really like the session to be pretty conversational. So we're going to really encourage you to give your thoughts in the chat and the Q&A. And if you want to share your audio and video and join the conversation with us later, you are more than welcome to do that. Because this is a really exploratory session. This is not one where we have something to present. It's one where we're mostly talking about the issue still and figuring out what the best things are to do.
I don't know if it looks like Albert's here. Hello.
Hello.
You can go ahead and share your video. Here. I think I saw Amanda in the chat too. So if you want to share your audio and video, and then we'll probably just get going here.
Yeah, I had to switch browsers for whatever reason. My first one was not playing well with the system.
Yeah, I think Chrome works best with Hopin, it seems. I don't know if that's what you're...
No, Chrome had a meltdown, so I had to get Firefox.
Well, there you go.
Great.
Hey, Amanda.
We have Amanda. Hey.
All right. Tiffany, do you want to try turning your video on? And then let's see. Oh, looks like I had to approve. There we go. Perfect. All right. So thank you, everyone, for joining. My name is Sarah Hinchliffe-Pearson, and I'm the General Counsel at Creative Commons. I'm joined by my delightful colleague, Kat Walsh, who's the Deputy General Counsel at CC. And as she mentioned, this is going to be an informal discussion. We are trying to replicate online what it would be like to sit in a room together and sit around a table and toss ideas. I was thinking before this session that I'm going to pretend that I'm at the 2019 summit in Lisbon, where we were kind of gathered in these lovely rooms together, having really nice conversations. So let's try to replicate that here if we can. We also want to have plenty of opportunity for not only questions and answers, but also hopefully getting people to use the functionality of Hopin where anyone can share their audio and video and intervene. So I will happily let people jump up as the discussion gets going. So please keep that in mind as we get going. So, but first, I want to introduce our illustrious panel here. First, Tiffany Lee is an associate professor of law at the University of New Hampshire School of Law and a fellow at Yale Law School's Information Society Project. She's an expert on privacy, AI, and technology platform governance. Her recent scholarship includes articles on privacy during the pandemic and privacy as a civil right. We also have Albert Fox-Kahn, who is the founder and executive director of the Surveillance Technology Oversight Project, or STOP for short. And he's a fellow at the Engelberg Center on Innovation Law and Policy at NYU. Kahn is a frequent commentator on civil rights, privacy, and technology matters. And as you'll learn during the session, he's been at the center of the debate around the use of photos to train facial recognition systems through his work at STOP. And Amanda Lewandowski, she's an associate professor of law at Georgetown and the founding director of the Intellectual Property and Information Policy Clinic there. Her recent work includes focuses on the use of IP to tackle tricky social issues of many types, including facial surveillance. So thank you all so much for joining us for this conversation. Just to get us going and kind of give a little bit of context, I was going to just spend maybe 2 to 3 minutes kind of teeing up and framing the discussion, because I know this is a huge topic, the intersection of privacy and open. So I want to make sure to kind of get us to home in on the particular slice of it that we're going to try to focus on today. So in a nutshell, the problem that we're going to try to focus on is that CC licensed content may be more likely to end up being used as data to train AI systems, including systems that are harmful and invasive. So for those of you that have been following Creative Commons for a while, this will be very familiar to you. I think it might be one of the most talked about issues related to CC licensing in recent years. The background to it, back in 2019, Creative Commons learned that researchers at IBM were using CC licensed photos to improve their facial recognition technology. And to do this, they accessed about 1 million CC licensed photos from Flickr and annotated the photos with information about the appearance of the photos, of the subjects in the photos, such as their skin tone and other facial features. And the data set was promoted by IBM as a step toward reducing bias in facial recognition. So I think it's probably worth stopping here just to briefly describe at the highest level how these AI systems operate. For those that aren't familiar, essentially the algorithms that underlie them learn by processing huge amounts of data. And in the facial recognition context, this means processing as many human faces as possible. And this is done by gathering as many publicly available images as possible. And while all kinds of images are scraped for these purposes, CC licensed images are a particularly sought after resource because of the copyright permissions granted to the images. Understandably, many photographers have been shocked to learn that their images have been used this way. There's a documentary filmmaker, Brett Gaylor, who many of you may have been familiar with. He's created a short interactive documentary about his experience, finding out that his honeymoon photos, in addition to hundreds of his other photos, ended up in many different data sets that were used to train facial recognition systems around the world. It's definitely worth checking out if you haven't seen it. There's also a research tool which Stop was involved in developing called exposing.ai that allows people to decipher whether their particular Flickr images have ended up in these data sets. So all of this raises some really challenging questions for the open movement. As the title of this session kind of provocatively suggests, can open sharing and privacy coexist? Or must we accept these harmful reuses of open content as a price for sharing? I hope not. Also, what role does open licensing actually play here? There have been some high-profile instances of CC licensed images being targeted, but this kind of processing is happening at scale, with including with images that are all rights reserved copyright. So that'll be another topic area. Now, the breadth of this, I think, can make it challenging to tackle. And there have been a lot of conversations about it in recent years. And so we were going to try something a little bit different here to kind of get us focused on action and maybe avoid having too much of just a theoretical conversation. We thought we would go straight to one proposed solution. So Albert and his team at Stop approached Creative Commons a few months ago about an idea for a new legal tool designed to give users control over how their content is used when it comes to this kind of AI training. So I thought maybe we'd start there, Albert, if you want to give us some background on that idea.
Yeah, of course. And thank you so much for having me, for organizing this panel, and just for your eagerness to engage on this issue. So, in my role at Stop, I do quite a bit to combat the effects of facial recognition and look at ways that we can disrupt the procurement and use life cycle. And one of the, obvious concerns here is how Creative Commons licensed images are being used to train facial recognition models, and then also how these same images can be used as part of the comparison data set for when a purported match is found. So it's both of those use cases. And so our proposal was to give individuals the opportunity, just as we say that you can require attribution with a license, just as you can prohibit commercial use of a licensed work, you should be able to prohibit the use of a licensed work for biometric surveillance. The idea being that this is a unique class of use that poses, clearly, far different implications than other types of reuse of a work. And, from my perspective, without this sort of prohibition, the Creative Commons license risks being at odds with itself by enabling these surveillance vendors to use these works in a way that is antithetical to the goal of the license, rather than broadening autonomy and giving us a more open world. By enabling these surveillance tools, it in fact creates a more constrained, surveil, and constricted world. And so the hope here is that by simply adding this, class of uses of biometric surveillance, defining that, adding that as a tag, that people can begin to choose to limit this reuse. And I would actually, in the long run, hope that we go even further and say that this gets incorporated into the default license, so that someone would have to explicitly take the step of enabling biometric reuse of a work before that was permitted.
Does anybody want to just generally jump in there with a initial response, or? Seeing no takers.
Yeah, I'm happy to jump in. I would love to hear Amanda's view, because Amanda's work is one of some of the work that I often talk about when talking about issues with open licensing, copyright, and privacy. But you're gonna have to wait a few minutes for her amazing opinion. In the meantime, I do have a few thoughts on this. I do agree, biometric surveillance right now is a net harm. We're definitely seeing a lot of terrible uses. We're seeing, unequal use of things like predictive policing, facial recognition used for something as extreme as a drone strike, right? We have a lot of really terrible uses of the tech. On the other hand, I'm still a little bit concerned about curtailing the openness of the CC license. And I'm concerned about this, not because I don't agree that the harms are really terrible for some of the uses we're seeing, right? Some of the AI uses. But I think this is a really big time for the community to decide, what are the values that we're trying to instill? And it's not enough to say that the licenses are apolitical. Definitely there are politics involved, right? We have a value of openness, we value sharing, expression, and so on. We also have a sort of value for things like attribution, right? Giving people credits. There's a value judgment in place when we have something involving commercial versus non-commercial, right? Those are all value judgments. So we can decide to have a value judgment against biometric surveillance. We can have a value judgment against something like military use, which someone in the chat is talking about. But these are really difficult questions. And I'm glad we're having this session, and I'm sure there'll be many more sessions, because I'm sure some of you, like me, are just not sure. I don't know if it's time for this value judgment to be made, partially because I'm not sure if we can say, completely right now, we should cut off all uses of biometric data to train AI, even for surveillance. There still might be some positive uses, and there might be some uses that at least are debatable. And if things are up to debate and we can't decide if this is something that we all value as a community, I don't think we should move forward with curtailing the openness of Creative Commons licensing. So I really do think we have to strongly consider if this is a value we all can agree on.
Oops. Amanda, are you talking? You're muted.
Amanda, I still see you muted on my screen. Oh no. Maybe if you reload and come back, we can keep talking on the topic while technical difficulties are sorted out. Yeah, it's really interesting to point out, and I'm glad that Tiffany pointed out actually that the licenses are not apolitical. A lot of people have said that they want them to be that way, and they're not, right? They're a response to the existing systems of copyright, using copyright to control expression. Like, we've decided that we want a different default for that, and made like very values-driven choices, and we just, we see them as neutral because we're swimming in it. Like, but what other value choices can we make?
And one thing I would add is that I guess the question is, what is the base case you compare this to? Because I would posit that where you don't allow for this selective sharing without permitting biometric surveillance reuse, there's an entire class of creators who you will chill from engaging with the license for fear that their works will be repurposed in this way because they lack the protections against that type of reuse. And so I do think that as we see a acute and increasingly global opposition to facial recognition, it makes sense to respond to the particular threat that poses and the particular need that a lot of users would have. Speaking personally, I would never post my own photos under a Creative Commons license if I believe there was a risk that my images would then be used in this way. And I want the ability to do that, to share in that way without that fear.
Is it working now?
Yes, it is.
We did it. What a great time we just had together. I just wanted to thank Tiffany for teeing me up so wonderfully. I'm so grateful. But I think I wanted to start off by saying that it's a real bummer that we're having a conversation about using copyright to fundamentally defend people's dignity and autonomy. Copyright, I've been working in the space of creatively using copyright for these kinds of problems since 2014, which started with non-consensual pornography. And my takeaway then as now is it's the best we have because lobbying efforts have made copyright so strong, and a lack of our ability to make privacy keep up or keep pace with that has made privacy so comparatively weak. So I just kind of want to set the table by saying, like, I'm glad we're having this conversation, but it also sucks because the reason we take down non-consensual pornography should not be because of the DMCA. The reason we don't have face surveillance should not because companies are scared of being sued because they're not sure that their use is fair use. Those are both really, I think, dangerous problems that we don't have answers to because that copyright conundrum privacy puzzle Venn diagram is starting to look more and more like a circle every time we have a crisis like this. But with that in mind, I think there's some really important background, I guess, that Sarah alluded to when she was talking about the ways that these systems work, right? And the ways they work in a lot of contexts is companies think that it's fine to use images because of fair use. Conservative companies went for the move of using Creative Commons licensed images to avoid the fair use question, thinking that they were licensing the images under the terms of the license. And then there's some people who just don't care and haven't maybe done an analysis on this and are just like scooping up everything and just seeing what happens. And I think we all know the kinds of companies I'm talking about. But I have written about the fair use analysis in the context of mitigating bias. And I think there's a really strong reason to believe that that kind of use is fair use. But it's really tricky when it comes to face surveillance because the purpose of the use under the fair use analysis is the same. Using profile pictures for face surveillance is particularized identification, and a profile picture is meant to be particularized identification, which means that even under fair use, it's possible that face surveillance actually doesn't qualify, only in some circumstances, only in a sliver of examples. But that's the scholarship that I'm currently working on, exploring that topic. I think for that reason, it's helpful to have a big, broad conversation about what we actually want to be pushing for parallel to this. Because I think Tiffany raises some interesting points about research. I think one of the challenges of banning all biometric research entirely for these images is it makes it impossible to audit or critically engage with the data as a researcher. There might be some other way, a creative lawyer, maybe a clinic could draft around that. There are some clinics who've drafted those kinds of licenses. The Technology Law and Policy Clinic at NYU is one of them, where Albert is affiliated with the Engelberg Center. But I think that thinking about that kind of question is, how do we let people do projects like exposing AI and excavating AI that critically engage with these data sets that may use these images without consent, without getting them into the same bucket as face surveillance, right? Not all face recognition is surveillance. And that's tricky. And I don't have a good answer for that.
So from my perspective, I think it obviously there's always going to be creative lawyers on the other side trying to pick apart these distinctions. But I do think it is possible to define a discrete difference between using these images to train an algorithm on the one hand, and using it for auditing purposes. So, and part of that gets into the non-commercial distinction, part of it gets in, and I just look at, some of the, legal precedent we have with, measures you can take in enforcing, in measuring disparate impact and things like that, and sort of some parallels you can work on based on there. So my hope would be that it won't be a straightforward drafting exercise, and we'll definitely need either the NYU clinic or another one to help with this. But I would hope we could say, all right, testing for bias, yes, that is consistent with values of Creative Commons. Doing an analysis and public education tool, sure, but making money off of people's faces by using it to train an algorithm or provide a generally accessible search tool, that to me feels like a discrete use case.
Can I ask a follow-up question? I think one of the challenges there is, what if people do want it to be commercial? The example I'm thinking of is there have been multiple movements to create like diverse image sets of just people doing like corporate business or like eating salads or like whatever it is. And they may really want to push that as a commercial Creative Commons image so that people pick up and use it and don't just have 5 white people sitting at a table doing the same thing all the time. But it's hard to then parse out when we can do the commercial, non-commercial for the biometrics, because that same image is going to be super appealing for face recognition because it's a bunch of faces doing well-lit things, right? That's like the money pot. And I don't think it's impossible. I just sitting here thinking about it right now, I'm thinking that's going to be a really tricky conundrum because some people may still want the commercial piece, just not for the bad guys. And I think that drafting a license that only targets the bad guys is really hard.
So, yep.
I'm going to jump in here with some of that also, which is like if you've ever used a royalty-free video encoding codec, for example, like a lot of that was trained on CC licensed video and free video of people's faces, and because they needed a lot of faces to be able to encode that well, and a lot of that has gotten used in commercial projects that didn't want to license the commercial options. So that's another way that we're really grateful for all the people who have put out openly licensed images of like their faces and personally recognizable information. That's hard to carve out if you're trying to prevent that same information from being used for like identifying them on the street in China.
So I think these are all great points. There are great things that we can do with the images, right? The research, documentaries, creative projects. But as Albert brought up, there are legitimate users, and I keep going back to this. I've been thinking about this. How do we protect the person who will not put up their creations if they're afraid that their images or their data set will be used for something, like military AI or something like, the non-consensual imagery app or something, right? Like a deep fake app. And I was thinking about this, in the past 5 minutes. And one of my questions actually is, why should this be a Creative Commons license? Like, is there a world in which we could have the CC license, and then we could have maybe a law school clinic or a nonprofit or advocacy group draft an additional add-on, draft a modification of the license or a new license entirely, or just something that some people could add if they're afraid of their data or their images being used. That feels like a project that could be doable. And it wouldn't necessarily change, it wouldn't necessarily involve having the entire Creative Commons community having to come together to determine their values around biometric surveillance, but it could be compatible. And that strikes me as a sort of middle ground. I would love to hear people's thoughts on something like that.
That is definitely something that we've seen as a possibility, but I think this gets back to Amanda's point in some way from earlier that it sucks that we are using IP to solve this issue, and part of the goal here is to use the broadest outreach mechanisms we have to try to reach as many creators as possible with this option. So that's part of it. And I think from my role as an advocate, part of the goal here is to help show a growing global consensus, on the morality of this underlying use case, and say that there is something different in kind, not degree, from having a creative work repurposed as part of a form of expression versus as a form of surveillance. That those two cases are quite different. They pose very different social costs. They have the distributive impact of the externalities is very different. And so when we're trying to evaluate the broader sort of regulatory scope of them, that it really doesn't even belong within the Creative Commons universe. That this sort of use case, from my perspective, is just really at odds with everything we're describing as the positive examples.
I love the idea of the Creative Commons universe, which implies the idea of like a Creative Commons extended universe. And maybe in that extended universe, we have like PP, a complementary project, like privacy project, right? That does privacy focused licenses and builds up a full stack and spins that out. But I think, Albert, your point in some ways is that we need to meet people where they're at. And this conversation is happening around copyright, for better or worse. And Creative Commons is really at the center of that conversation through really no fault of its own, finding itself in this situation because of a totally separate social movement. And if we do want to have some impact, maybe to answer Tiffany's question, that's the reason, is because people are looking at this as a copyright question, for better or worse. And if we give them a privacy answer to a copyright question, to me, the intersection that Albert put together of, this as an advocate is where we need to be having this conversation about expression versus surveillance, and making making sure that that's not a fine line distinction, that's a bold line distinction. I think it's also just as important to say, copyright conversations no longer get to just be about copyright. Like, we have kind of moved past that, unfortunately, because of the way people use copyrighted works and because of the way people are doing things with them. And because of that, we now have to have a conversation that's copyright and privacy together. And that's how we end up in the Creative Commons extended universe, I think.
I do love the idea of this as a entire franchise series, and with TV spinoffs and everything as the MCU equivalent. No, but I think some of this, to just thinking of Rob Benjamin's work, Simone Brown's work, like, we can't have a neutral technical system here. We're going to have a technical system that is affirmatively either making the choice to support these state actors in the procurement of these systems, or which is taking a stance against it. And it's sort of, again, completely agree, Amanda. This is not something that Creative Commons, that the community wanted to be in the position of deciding, but by virtue of how these standards are used and relied upon by so many millions around the world, it is the place where you are. And so that means that it really turns into this binary choice, unfortunately.
Yeah, I guess my personal opinion is we've come to a point where it's really artificial to try to talk only about copyright and ignore all of the other issues. But at the same time, I think there's a lot of thinking that I guess I'm still doing about whether, to me, that doesn't necessarily mean that that this is something to add to the Creative Commons license suite, or that Creative Commons should even address. I guess one of the things that I really am interested in hearing from you all on is just, I guess, the risks associated, or the consequences with making this an individual user responsibility, as opposed to, because essentially, if I understand the proposal correctly, it would be up to the user to decide that they don't want these things to happen, and apply the particular license. And what does that mean for everyone that has already put content out there that doesn't mean that you can just run rampant. That seems like one unintended consequence. And also just thinking about opportunity costs of where we put our efforts on the privacy front. Is individual control the right methodology? I'm curious to hear your thoughts on that.
I want Albert to go first because he took himself off mute.
Oh, you took yourself off mute first. That's why. And all right, I would say quickly, I think the stronger version of this proposal is that you have to opt in to allow the surveillance reuse of this technology, and the weaker version is that it is a optional tag where only if you select it as a restriction would you then prohibit that reuse. And I think that precisely because, well, I think we know that default rules are effectively reality for the vast majority of users, and also because of the distributive impact of who is going to take the time to make that selection and go that step further. And we're going to effectively privilege the more privileged users in a lot of cases where we make that privacy protection something where you have to take an additional step. So definitely my in an ideal world, it would be categorical. I think realistically, it would be that you have to opt in to allow that surveillance use. But then the weaker version is, that you would have to. It's something where surveillance is allowed unless you opt out.
So I think this is really interesting. This idea of having the default license be a specific anti-surveillance license, right? Or an opt-in anti-surveillance, choice for your license, right? Both are interesting prospects. I really want to think a little bit about what we're trying to achieve. So Sarah talked about this, putting the onus on the user, right? Either to say with the license or opt-in or whatever, it's still based on the individual user. And I think we need to separate two potential goals here. One goal is actually curtailing the use of images and data in surveillance, and therefore potentially decreasing or stalling the development of surveillance technologies, right? That's one potential goal. Another potential goal, which Albert brought up earlier, is simply this idea of creating a new norm, right? Changing the norms of what we believe involving surveillance and open knowledge and information. And these are two very different things. And I mention that because by creating a license, by changing the license, either by default or opt-in, to include a surveillance type of clause, we definitely would create an impact on the global norms about surveillance and images and data. I'm not certain we'd have the impact about decreasing the actual surveillance. So these are two different goals. And if we're trying to achieve both of them, we should really consider what the effects will be. And I don't have the empirical research on this. I'm sure it exists somewhere, right? At least, we can extrapolate based on copyright, right? So I would like to see some research and think a bit more about that. If we're good with just the norm shift itself, that's fine as well. But if we want specifically to actually decrease the tech, the surveillance tech, then I'm not sure if the licensing will be enough.
It's such a good point.
I was actually going to make a very similar point to Albert's about whether or not we want to think of this as an opt-in or an opt-out to change the conversation we're having about the user. So I'm glad you framed that up so beautifully. One other thing to think about is maybe this isn't really a conversation about two separate values around copyright and privacy. It's a unified conversation about consent. And consent for copyrighted images just looks different now because of the threats of face surveillance. It's actually extremely on. My cat's about to come into the screen, sorry. Conversations about consent are super on brand for Creative Commons because the conversation about copyright is extremely on brand for Creative Commons. That's like the bread and butter of the whole thing. And so for that reason, I think maybe taking that more unified approach to we're just giving more tools for you to figure out how you consent to the use of your image. We're giving you more tools in your arsenal. That doesn't feel like two separate conversations anymore. That feels like one really holistic conversation. She's having a great time. She's loving this. So that's one piece, is maybe reframing it around consent. It provides sort of like an overarching theory of why this might be the right place at the right time. The other piece of the puzzle is, I think there have probably been chilling effects about people who creatively contribute to the commons because they're concerned about this problem. And that feels very squarely like a Creative Commons problem. If people aren't using Creative Commons licenses because they're afraid that their images are going to be appropriated by Clearview AI, that actually really affects the movement. It really affects the ability of people to engage in an open ecosystem, which is sort of the point. And I don't have data on that, but I know that in response to the IBM revelations, there were a number of people who anecdotally said, I'm no longer going to use Creative Commons license images because I don't feel safe and comfortable that I can use those in a way that complies with my consent. And so I think that also is a pretty square Creative Commons problem, that people are abandoning the license and not contributing to an open ecosystem because they're afraid of this surveillance. And that might be another reason to get more actively involved in shaping that conversation around consent, because that really does affect the movement in a pretty direct way.
And I think that point about consent is brilliant, because I think if you were to survey Creative Commons users, I would be shocked if a majority said, oh, I actively want my work to be used as part of this surveillance system. I don't think you would find even, more than a tiny fraction. And so when the consent afforded by the legal document isn't aligned with the subjective intent of the user, to me, that seems like a disservice. That, what if this is all rooted in agency, in giving people control, then the tools of control should match what they actually want to see, how they want to see their works being used in the broader world. And I definitely think that when you think of the people who will be chilled from using the platform, it's not me. Like, it's not, a middle-aged white guy who's going, a lawyer who's going to be most impacted. It's going to be my clients. It's going to be, BIPOC individuals, undocumented individuals who, have criminal justice involvement, who are now seeing that their works can, pose a threat to them in ways they didn't expect before.
Kat, you went off mute. I thought you were going to say something.
Oh, yeah. So looking at this from my perspective at Creative Commons, I feel like I don't disagree on the desired ends of pretty much anyone speaking in this conversation, but we only have, I wish we were so powerful as to create the kind of social change that, even the copyright tools, just thinking of the copyright effects of them, are only empower the people who are really informed, like know where to look for them, know how to use them, know where to find them. And to some extent, like, does that, it feels a little less morally questionable to have that for copyright, where it's a little bit more fluid, where the effects are less directly personal, come to less like direct personal harms and privacy harms you. I just feel like having a tool at Creative Commons is too small. And that's where when I saw the proposal, that was my first thought about it, that it was too small, that that we couldn't really do very much about it. Like, we don't have that broad an uptake, and even if we tried to enact it, it would just get ignored. People would find other ways of getting what they want rather than relying on the licensing, which has always been just kind of convenient.
I feel like you're selling yourself so short. Creative Commons created an entire ecosystem by which people could allow strangers across the world to use their works in other creative ways. That's radical. And I think that taking that same kind of ethos and applying it to something like consent could be really powerful, because Creative Commons is a real, and I say this with love, a hefty player in this field. If all you do is present a very bold, very visible road bump, it's not a roadblock, it's just a road bump. But when people go over it, they're going to notice, they're going to see it coming, and it's going to say something to them. And I do think that does something. The other thing that's really powerful here is there are means of potentially being creative about having conversations around this that might open up to Creative Commons by getting into this fight that may not otherwise have been quite so on the radar. This is going to get litigated. And there might be it might not be around Creative Commons licenses, it's probably not going to be. But that might be an opportunity to write an amicus brief that focuses on, we talk about consent at Creative Commons, and this is why we bring these two issues about copyright and privacy together in conversation. That's a kind of amicus brief that no one else in the country could probably write with any sort of authority. And I think that's something to think about too, is that even though we're having a conversation about a license, this is not really about a license, because if you make a license, you're creating a new movement. And Creative Commons is pretty good at creating movements. And so that's something to really reckon with.
I so agree. And I look, Kat, I completely agree as well with the point that this isn't enough. It isn't. But thankfully, this isn't the only campaign we see unfolding against this technology. We see, a growing number of bans at the state and local level. We see, more countries that are pushing back on the growth of this technology. We see these broader public movements. And I think that, having this support also goes a long way for all the reasons Amanda said. It can, Creative Commons is uniquely positioned to address this one component of the harms from facial recognition. And I think that, I guess I would say, if there isn't a downside, if there isn't a countervailing harm, then we want to avoid turning perfection into the enemy of the good. If it advances this even a small amount in the right direction, that's still a really important step in a really timely fight.
I wonder if it makes sense to shift then the conversation to maybe some of the creative lawyering aspects of how we would. Is it viable? I mean, because I guess one harm I could imagine is if we made a flawed tool that gave people a false sense of security and didn't actually do anything, that probably wouldn't help with either the norms or the practical aspect. So what are your thoughts on how we might structure something like this? Is copyright enough? We just we lost Kat, but she'll rejoin.
So, I mean, only 7 out of the 14 top training data sets for facial recognition are currently using Creative Commons licenses. So even in the best case scenario, this isn't going to fix the entire universe of issues. And it certainly won't do anything about the models that are already trained. For me, I think the most important components of this are, how do you define applicable biometric data in a way that future-proofs it against types of biometric analysis we haven't even considered yet? How do you carve out the small subset of use cases that we consider positive, such as auditing and bias testing and things like that? And then between those two sort of restrictions, can you essentially cabin off all of the existing and planned forms of biometric surveillance that out there on the market, both on the training data side and the comparison set?
So you're talking about.
I think that's a great, yeah. I think that's a great list, and I hope someone has that in recording or written down or something, because I definitely can see, if we're going to go with this, right? We say, this is what we want to do. We want to make this big announcement. We want to create this shift in norms, right? And maybe it will also help practically, but we really want this political statement, right? Then let's think about how to do it. And I think it's important we cabin off all of those things you just mentioned. I'm really thinking, so I'm based in Boston. I'm surrounded by researchers, right? A lot of them are working on tech. And there's so many well-meaning researchers who are using, CC licensed images, right? Even for, sometimes not for facial recognition necessarily, but for, image recognition, right? Facial detection, perhaps, or movement recognition, gait recognition, doing analysis. Someone I know does interesting research, scraping YouTube videos for videos of people walking, and using that to make models on how people walk and how people fall. For potential medical tech, right? So there are some interesting uses. And I really want to make sure, if we want to move forward with this, we need to protect those people, right? The researchers who are doing the good works, people who are doing, as Amanda suggested, like audits for bias and so on. And we'd have to think about that, because that's the countervailing harm that I see, right? That's something that we really care about we're all here because we believe in open knowledge. And any limits on open knowledge have to be done very carefully. They've got to be done for a good purpose, maybe potentially stopping worldwide surveillance disproportionately harming Black and brown communities all over the world. Maybe that's a good purpose. But even for the good purpose, we've got to be very careful because right now, these are our value judgments. And as you mentioned, this is the tech we have now. I don't know what it's going to be like in 20 years. I don't know what it's going to be like in 20 years if we push everyone doing the bad stuff, off of these platforms, right? If we say that, all those bad actors have to get their own data sets, proprietary data sets that we then can't see or can't audit, I don't know what that world's going to be like. And I want to make sure, the future proofing that you mentioned, the future proofing has to be done not just to protect the things that we want to get out of it, the privacy protections, but also to protect against the harms to the researchers, to the creatives, to the idea of open knowledge. So that's something that we really have to keep in mind as well.
Yeah, and I think that's one reason why I'm really focused on one-to-one identification. I think there's a lot of creepy stuff out there with gait analysis, with behavioral analysis, with, oh my gosh, all the pseudoscience around, we will look at your photo and predict what you're thinking, which there's no evidence that any of that works. I think that stuff would be harder to describe in a way that isn't going to also get medical analytics tech and other related technology in it looped in. But I think if we're just talking about technology that has the ability to identify an individual, that is a discrete use case that is easily described, easily included in the license, and then easily differentiated from all of these other edge cases.
I don't know if I agree that it's necessarily going to be easy, but I think that it's probably possible. And that's where I think, Sarah, you kind of kicked this off by asking about what the lawyering landscape looks like. I think it's going to require some really creative lawyering. I also think it's going to require the community to look at these licenses and come up with these edge cases, right? We've come up with quite a few, but we're not the only people who have a dog in that fight. The community is also going to be really invested in making sure that people can use their works when they want people to use their works while retaining their, consent to not be a part of a surveillance dragnet. And I think in order to get there, it's not just creative lawyering, it's making sure the community feels like they're being involved in this conversation. I think this is already a great start to have the community introduced to even the slightest, remotest possibility that Creative Commons may be dipping a toe in this conversation in a pretty meaningful way. But if that conversation continues, I think bringing the community along for the ride, as Creative Commons has always done, is really a part of that conversation too.
Oh, yes. I feel like it's definitely something where the distributed creation process that defines Creative Commons is going to be indispensable in getting this right and thinking about a license term that isn't going to have unintended consequences, isn't going to be under-inclusive, and is going to be at least remotely resilient to changes in technology. Because my big fear here is always something like, I don't know, the Electronic Communications Privacy Act, or one of these sweeping, privacy statutes that's basically a dead letter as soon as the ink is dry.
I feel like that's a big problem. And as Sarah and I were both involved in the 4.0 drafting process and trying to future-proof things so that they weren't too specific and we didn't have to version, every year or two, was actually really difficult. And a lot of the community issue with terms that are very vague and difficult to interpret actually come from that, trying not to box ourselves in and limit ourselves to one particular implementation that might change in a couple of years. So I definitely see that as an issue.
I wonder, I saw that Jonathan's asked a couple more detailed questions about the role of copyright here. Amanda, do you want to talk a little bit more about your upcoming paper, maybe?
Sure, coming law review near you. So basically, one of the really challenging things is that at least some of these companies are not just extracting facts from faces. They're copying the entire image onto a server, and then they're replicating that entire image in response to probes or search queries from law enforcement. And that is not a fact, that's a face. And that face happens to be protectable copyrighted expression. And I think that's where that distinction lays, because the technology to extract just the facts from the faces at the scale that that's being done at would be truly phenomenal. And I've seen some examples in terms of the probes that have been responded to that actually show the faces. They're definitely being replicated in their entirety, not in an abstracted form, but in the actual copyrighted photograph is being reproduced. But even if they were operating on that scale, that's not something we're seeing for a lot of these companies. So for a lot of these companies, copyright is still a problem. So that's my little short answer to Jonathan. My paper talks about it more. It goes through a fair use analysis and talks about some creative ways that an enterprising lawyer might be able to talk a judge into saying this particular type of use. As many examples of machine learning that are fair use, there is this small sliver that doesn't really affect the others that is unique. And I think it has to do a lot with that first factor, right? Because the purpose is the same, it's particularized identification. That doesn't carry the day, but I think that's part of the persuasive TLDR, just to tease it out and see if you go find the paper on SSRN soon. And then the second conversation, or the second question was sort of like, what about targeted legislation? That would be so great. And in the paper, I say we need a ban on this technology. Copyright is a distant second to get to a place where this is no longer a viable option. Unfortunately, legislation dealing with this issue has been introduced multiple times at the federal level and has not gone anywhere. However, it has seen great success on the state and local levels. There have been a number of cities and a number of states that have passed biometric regulatory oversight legislation and really seen their communities rally around it and have it make a difference. The problem, of course, is that people live everywhere, not just in those places. And if we want to protect everyone, particularly because, I'm from the Southwest, there's not a single biometric regulation in the entire Southwest. That's a huge swath of the country that has zero protection. Holla at Arizona, right? Making bad choices, but we still want to protect those people even though their legislators are not protecting them. And the only real way to do that is to get a ban. However, because that ban is not forthcoming, I think, and as I argue in the paper, copyright can get the job done for now so that we can avoid a full-blown dystopia. Right now we're like toying with dystopia, but the full-blown thing could be potentially put off. Maybe. We'll see.
I completely agree. As someone who does advocacy work at the state and local level to try and outlaw this technology, I will shamelessly plug banthescan.nyc, where you can learn more about our efforts to ban facial recognition in New York City and New York State. I think that this is a generational fight, right? And we're outlawing it city by city, state by state, building this momentum. And it's going to take a huge amount of momentum to get that federal legislation eventually that's necessary to completely protect our country and a lot of the people we're spying on around the world from this technology. But it's going to take a lot to get there. And I think anything that helps show a burgeoning global consensus against this technology only advances that. So I definitely agree that the more we use copyright to go after facial recognition, the more it helps the efforts to get stronger legislation that bans facial recognition completely.
I can't stop going back to Amanda's initial point about how sad it is to be using copyright for these huge systemic problems. I guess I just have a hard time stomaching that is our best solution. Well, Congress reduces you to a lot of absurdly depressing tactics at times. But no, I mean, in a well-functioning society, we would be in a better place. But, I guess I would say I would love to be wrong here, right? I would love if someone in the chat could point to the readily achievable alternative that we can use to stop these same harms. But I don't know what those are.
The very cynical part of me says that this is a great part of a campaign to make copyright less powerful by making it more powerful.
I think that one of the nice things about a solution that does use copyright is it doesn't have to make copyright more powerful. It just takes copyright as powerful as companies have made it and happens to apply it to the powerless. And that's really where I think it gets a lot of its strength, is that if you use it correctly, wielded correctly by the powerless, copyright can provide a really powerful tool that doesn't touch other things in the ecosystem, other things we love. We could actually do this in a really targeted way that gets the bad stuff without hitting all the good stuff. And even though that sounds like a real hat trick, I think it can be done with clever lawyering and clever analysis and clever movement lawyering. And I would really love to see that happen. I think that would make a pretty big difference in this fight, to show that using copyright in this way doesn't make it more powerful. It doesn't make it more dangerous for the things we love, but it can really do a lot to protect the people who need it.
I think it comes down to, again, the goal of this, right? We are talking about trying to affect global norms through this, basically a political statement, right? And I think that that can be valuable. I do think, though, again, we have to be careful with that. I liked that. I think it was Amanda who was talking about the involvement of the community. And someone in the chat is talking about sort of the global consensus. Is there a global consensus about this? And I think that if we are trying to make any political statement, we have to recognize it's not just going to come from Creative Commons. It's going to sort of be coming from the open knowledge, open source community. And that's something that's a broad conversation, right? I am not sure if everybody agrees on this. I think that we all agree on the extreme cases. We all agree that certain types of surveillance are bad, or most of us agree. But not everyone agrees for things like, let's say the medical analysis tech. Some people in the comments said that that's usually just, a cover-up, right? And there's a hard way to draw a line between things like facial recognition that harms political dissidents, and potentially using facial identification to know when someone's at the door of your lobby. Or using something like, facial recognition so your phone can log you in, right? Some of us find that very creepy. Others find it extremely convenient. And I do think we have to consider this. If it's a political statement, why are we making it? Will we get what we want out of it? And again, the harms, right? Can we protect against the harms? Maybe we can. I do think a limited version of this license that we're discussing that specifically still allows for research and creative uses, and even potential commercial uses if people wish, that could be something that is practicable. I can see, some creative lawyering, as Amanda mentioned. Maybe the litigation that results from it could be even more impactful. But I do think that it's something we can't just say yes to immediately. This is a conversation where we just have, 5 of us and, a few dozen of you watching, and we're not saying yes to anything. But it's something we have to really consider more. What are the limits, right? What's the counterfactual? What could happen what are the bad things that could happen with this? Will this actually create anything different? Will it mean that the surveillance that develops is actually worse? Will it mean that people are not able to do the good things that they want to do, right? So I do think we can move forward, but again, I really think we have to move forward with caution.
Definitely.
Yeah, and sorry, go ahead, sir.
No, I was just gonna say, yeah, definitely. This is not a session to kind of decide whether or not we're going to do this. It's just an exploratory conversation, but and definitely something we would not do rashly.
Yeah, I think in a room full of lawyers, we all agree that it comes down to the fine print. It's going to come down to how this is drafted, what the exceptions are, what the terminology is, and all of that. But I think that we can still, I hope, find a consensus for the need to move forward, even if the precise contours that are unclear.
Is anyone else's audio? Is it choppy? I couldn't hear Albert.
Yeah, it might be Albert's audio, actually.
Yeah, it's glitchy. It's just like a little hard to decipher.
I was saying that it's going to come down to the fine print on what we say and how we move forward, but I hope we can find consensus, move forward and move forward.
No, I don't think we could catch that, or I couldn't catch it.
Yeah, you might want to refresh, Albert. Or you can type. I'm sure you're going to say something really great. It has been great listening to, talking to all of you. I learned a lot and raised a lot of thoughts. It's a really interesting question, right? We're all going to have to figure this out. And I'm glad that the community is considering it. Open knowledge is about openness, but we've all known all along that there are limits. And if this is a limit that the community agrees on, then we've got to figure out a way to do it. Maybe with creative lawyering, maybe with something else, but we do have to think about this.
I think one of the marks of a successful panel is that it does actually shift your thinking, and I think many of the things said did actually shift my thinking on this. So I'm really glad to have had all of you here.
Same. I'm going to be thinking about that. The consent framework is a really interesting way to think about it. So thank all of you. I think we're actually pretty much at time, and we're having audio issues, so we can probably call it a day. Thank you all so much for participating, and thanks everyone for joining.
And thank you to the session moderators also, who have done a great job at managing the chat and resolving everybody's issue.
Yes, thank you. All right, take care.